All right, let's go ahead and gather together again. I may be starting a little bit early, but parties probably aren't opposed to that. Okay, well, let me just start just with the just a brief recap of the relationship of the parties. It sounds like the parties got together early in life. I think Ms. Schoenborn indicated that since age 14 that they've been together. And that has its pluses and minuses, I think. And here it sounds like the relationship was strained during the time that they were together. And certainly drug abuse and addiction issues certainly didn't make that easier. But it sounds like there was a pattern that developed in the relationship where they were quick to argue, and not a lot of grace was extended in either direction on a regular continuing basis. The parties have two beautiful and amazing kids. And that's to be rejoiced in and vaunted. That's really great. One issue that's needs to be addressed at this both with the constant or I guess regular, I'll say regular arguing or disagreement. The kids were subjected to verbal domestic violence, if you will, on a regular basis, and certainly that wasn't in their best interest and was obviously unhealthy for them. I think it's important to note also that the May 3rd, 2020 event, a very, very scary, very, very concerning event. I'll also note that there were no indication of prior physical acts of domestic violence prior to that time in any of their relationship. At least no police involvement had occurred. And the indication was that from the parties that there had not been. And so there was a significant blow up that occurred on this particular date. Mr. Schoenborn was physically violent towards his wife and restrained her and wouldn't let her leave. She was injured both in her arms by being restrained and fell to the floor and hurt her knee. The daughter, Kenna, was injured with a boot, and that was thrown with some degree of force, hitting her in her hand, causing it to at least redden and swell. And I think from a young woman's vantage point, that would be terrifying when you see parents arguing and really not using their best behaviors, and then being struck by a boot thrown by her father. It's really got to be scary. Adding to the kind of the fear of all of this was the fact that mother was not allowed to leave, and there were active efforts to prevent her from leaving. Mr. Schoenborn indicated that in times past, he was the one that would generally leave and get out of the house. And he explains that that's what he was doing. He was going back to retrieve his Suboxone that he had obtained in unjustified or illegal means, and grabbing his concealed pistol, which apparently he carried with some regularity. So those are the two varying, that's the one explanation. Then the mother's explanation is that the degree of the conflict was of such a high nature that when the gun came out, absolutely terrified. And from her vantage point, she probably thought she or the kids were going to get shot. And that's a horrible place to be in, and has obviously long-lasting impacts on people and children. So that's the backdrop of what precipitated the demise of the relationship. From that time, the focus has kind of really been, as far as this parenting plan, of what's been happening with Mr. Schoenborn. We all appear in this life with varying levels of gifts and weaknesses and strengths, and that we're born to bear, if you will. And Mr. Schoenborn has some biological issues related to anxiety and depression, and those have manifested themselves throughout the relationship. He had dabbled in drugs early in his life. Apparently he was clean for a period of time, clean meaning from illicit or non-prescribed medications. Continued to use alcohol, which is a widely accepted drug, which causes tremendous sorrow in a lot of homes throughout our world. So he was actively using throughout the marriage, if you will, whether it was alcohol or drugs. and with real no indication that there's any sustained period of non-use. His job was heavy, lots of stressors and lots of responsibilities, and not having necessarily a good support system, he turned, unfortunately, to those substances. And with the relationship and the state that it was, there wasn't a lot of support either way. Sounds like Ms. Schoenborn bore much of the child rearing, the day-to-day efforts, which is a heavy burden, and one that I sensed that she enjoyed and was happy to do so. And I think the same with the father as far as his role as far as breadwinner and the like. So that's kind of the background. Let me just kind of get to the meat of the issues that have been presented by the parties. So the issue of child abuse under 3A, all the other issues under 3A are agreed. The issue of child abuse, the thing that strikes me there let me just pull up my notes here. And I'm going to use, just so you're aware, I'm going to use Ms. Baldwin's document as kind of a working copy, and I'll make reference to that. And at times I'll make reference to Ms. Holder's document also. So the domestic violence, the assault findings under 3A, I believe it is, are appropriate. The child abuse, when I think of the child abuse, was there abuse of the child? Was there an assault? Yeah, there was an assault. The child was hit by the boot. There's some indication that may have been intentional, may not have been intentional. Nonetheless, the child suffered injury. What strikes me is that impactful? Absolutely, no question about that. But is there a pattern, or is it pervasive? At least in my mind, that's kind of the controlling factor. This seems to be a one-off, at least towards the daughter, Kenna. So I'm going to strike that finding or that requirement under 3B under child abuse. So I'm just going to put a squiggly line through that. Regarding 3B, Bravo, where it's talking about neglect, emotional, physical problems, substance abuse. Obviously, neglect and substance abuse, I think those are appropriate given the nature of his work and the like. And it seems like that was his focus during the week, and then there's a little more free time on the weekend, notwithstanding supervisory responsibilities interfering with family life. The emotional, physical problem, what I look at there is that I think this has been the depression, the anxiety, the panic attacks. They've been there for a long time, and they've been problematic. It sounds like at times they've been under control with medication and therapy. And maybe when one was stopped or the other was absent, that wasn't the best combination. It seems like with both of those issues being present, there was good outcomes and that kept things under wraps and controlled. So I am going to include the emotional or physical problem because I think that the emotional issues related to the anxiety, panic attacks, depression, and the like have been present, and I think that is also manifested by the need and the use of substances to cope with certain life pressures. So I will include the 3B. Regarding the alcohol, mind-altering substance discussion, I understand where both parties are coming from on this. I hear where Ms. Schoenborn's coming from. It's like, well, this has been a long-standing issue. And we had this horrible blow up, just absolutely terrifying event, and that he can't ever go there because kids are involved. And then I understand where Mr. Schoenborn is coming from, that he's concerned based on past litigation and concern for being brought up on contempt charges and the like for being present when alcohol is being served. I think when a person has had issues with addiction, that the best course of action is to stay as far away as possible from alcohol, mind-altering substances. And if friends are engaging in alcohol consumption, I think they stop to be your friends because there's been a pattern here when the drinking is occurring there. Maybe the other skills that can be relied upon to cope are not being implemented. And staying far, far, far afield from that, I think, is absolutely crucial for the long-term well-being of these children. So I will include an absolute prohibition of consumption of alcohol and mind-altering substances by Mr. Schoenborn, and that may certainly require him to alter his friendships and scope of associates. And, I'm assuming Mr. Schoenborn has had plenty of experience in counseling related to expanding sober networks, sober network of friends, whether that's a sponsor and the like, and widening that. Sometimes that's a very hard thing to do, but absolutely essential for the well-being of these children. Because I think it sends a clear message to the children too, is that, hey, dad's had some issues with this problem, these issues in the past, and you know what? He's making a wholesale change, and he's showing that you can overcome these things, and you should be overcoming these things, and you do it by staying as far away as possible from them. So I will include under the 4B, those prohibitions, including the firearm prohibitions. The evaluations are appropriate for domestic violence, including treatment recommended by the treatment assessor. SUD treatment and evaluation and treatment is appropriate. The psychological evaluation is requested by both. Here's my sense. I think probably most every single human being would probably benefit from a psychological evaluation. The person that tells me they're not damaged or wounded in their life, I don't believe them. Everybody has some scars, everybody has some wounds, and everybody could probably benefit from psychological evaluation and counseling. Here, when it's the state of Washington, the government is requiring X, Y, or Z, I'm a little more circumspect with that opinion and thought. The psychological evaluation may very well uncover some issues that have not been dealt with, and that Mr. Schoenborn has maybe not aware, or maybe it's a persistent under the radar type issue that an evaluation might be able to uncover. And if it is, then there was some treatment would hopefully alleviate that and would make him a better parent and a better father. So I am going to include that, the psychological evaluation for the father. Would Ms. Schoenborn stand to benefit from a psychological evaluation? Probably, but I'm not going to order it. Under, under 5A, under the parenting plan proposed by Ms. Baldwin, I simply removed the X's under joint just to remove any confusion that it might be joint, but then it says limited to the mother only. So I removed those X's that were under those boxes under joint. So it makes clear that mother has the limited or sole decision making. Going to the parenting plan, I think that I understand where the parties are coming from. I understand the mother's reluctance of moving anywhere, anytime fast, given the track record of Mr. Schoenborn. And I also understand where Mr. Schoenborn is coming from, is that he feels that he's possibly in a better place now that he's employed. He has the ability to engage in mental health services, maybe on a more regular basis. And maybe there's greater self-esteem that's coming through having a full-time job that will allow him to be more consistent in his treatment and utilizing his skills. So when triggers do come up, that he could do something, you rely upon those and not substances. So looking specifically at page 5 of the parenting plan under section 8, we're at line 21, 22, where this is phase 2. Where on the second line, where it starts reading on the first paragraph, the second paragraph under line 21 says, prior to engaging in phase 3, the respondent shall evidence he's clean and sober for a period of no less than 6 months. I reduced that from the 12 and wrote in 6 months. I also indicated later on that next sentence where it reads, he shall provide proof by the 19 panel hair follicle every 3 months for a period of 6 months. So I changed that to 6 months and then put a period there. Then at the last line on page 5, I just simply put phase 1 and phase 2 can and ideally will run concurrently and struck the remainder of that sentence. Under phase 3, the one indication that I wanted to include in there in Ms. Holder's proposed parenting plan, she had some language that the mother was obligated to choose the children's counselor, an in-network counselor, within 30 days of entry of the orders. That should be included within the parenting plan. And I didn't take the time to write that in there because it's a lot to write, and I think it would have messed up the kind of the vista, if you will. But I would like that to be included within that phase 3 language. And specifically, I'm looking at the language on, let's see, I'm looking at Ms. Holder's document, and I didn't note it. Let me find it here. There it is, at the bottom of page 5 of Ms. Holder's proposed parenting plan, where it says phase 2 reunification counseling. The mother shall choose the children's personal and network counselors within 30 days of entry of the orders. So actually, that's probably small enough that I probably could include that.
You want it within, that isn't, wouldn't it be more logical to say within 30 days of him making the 6 months? My concern is that unfortunately, as you're probably come across, the providers seem to be somewhat rapidly changing. So mom could pick an in-work provider today, tomorrow they're not there. And so it might be slightly better to choose contemporaneously with sort of that next phase. Or choose within, if he provides 5 months clean or provides, something along those lines, just so it's slightly more contemporaneous for when those people are needed.
Well, this is, I think these are the children's counselors that are supporting the reunification counselor. So I think that's the language where it says, each child shall be provided with their own counselor. The mother shall choose the children's personal and network counselors within 30 days of entry of the orders. So that's going to be occurring prior to the actual any reunification with the reunification counselors happening. So this is kind of the lead up, I understand.
Okay, that's fine.
So maybe we could I could include that.
You could include that on page 6 of my plan, right?
That's
I think
what
you can
thinking.
squeeze it in between, like line 5 and 6.
Yeah, Ms. Holder, you okay with that if I were to slide it in there?
Yes, Your Honor.
Okay, so I'll put that there. Okay, thank you. I appreciate that input and discussion. Then I'm okay with the remainder of the language there for phase 3. Under phase 4, this is where some in-person visitation, professionally supervised, happens once per week for up to 3 hours. I think at this juncture or junction, I'm not sure what the difference is. But in this phase, I think the alternating of attendance at the children's events can and should occur. So I'd like to include that language to occur within phase 4, and also that as far as transportation of the children to those events when it's the father's time, I'm okay with that, subject to the guidance of the reunification counselor. So there's kind of a presumption that father can take the children to the events and attend them on those alternating basis, subject to basically a veto vote from the reunification counselor. And so I'm hoping that could be included within the phase 4. And I know that that's included later on, I think in paragraph 14, but there should be some reference to it in paragraph related to phase 4.
This would be unsupervised time at phase 4. Is that what you're intending to create or no?
Well, I'm glad you point that out, because as I started my comments, I indicated this was in-person supervised visitation, which is kind of the first time for this. So I appreciate you pointing that out. That's my intent is to allow as much time as possible, but this is still kind of the early stages of the supervision, which I think is important. If Kenna is able to come around and participate in this, I think this would provide her with an added level of security and stability. So let me pause on that just for a moment and see if that would be better placed. I think it's probably better placed in phase 5. So I think we better put that in phase 5. And I think there that if that's where it's at, then we don't need to have the reunification counselor veto power spelled out. I think obviously if at that point there's any issues, then the reunification counselor notices any issues, the reunification counselor is going to make that known. They're not going to sit quietly on that. So I don't think there needs to be explicit reference to the reunification, subject to reunification counselor's approval or anything like that. So the phase 5, father can transport the kids on those alternating events of the children's activities. So then looking at phase 5, I'm looking at line 17, 18, where it says the respondent may have in-person visitation, which is unsupervised once per week for a period of 4 hours. So I changed that number of hours there to 4. And then under line 19 and 20 of page 7, it says phase 5 shall last as long as necessary, considering input from the children's counselor and reunification counselor, but for a minimum of 3 months or 90 days. So I don't want to unduly hamstring the counselor if things are going well, but if there are things that are not going well, the counselor's able to address the issues before we move out of phase 5. Under phase 6, I simply added on line 26, where it's talking about the in-person visitation every first and third Sunday, 10 to 4. I indicated that would be for a period of 3 months. And then thereafter, there could be first and third weekends, Friday to 5 p.m. to Sunday at 7 p.m.
Can you say those times one more time, Your Honor?
Pardon me. Then first and third weekends from Friday at 5 p.m. to Sunday at 7 p.m.
Very good, thank you.
Thank you. Next, then I'm moving through several pages, turning several pages to page 12, which is paragraph 14. And this is under 14G as in GAL. And I said that the telephone and media access can begin at phase 4, subject to the override power of the reunification counselor. So that phone media access could theoretically begin in phase 4, subject to the guidance and power of the reunification counselor. And also maybe under 14H, where it says that the children may be accompanied by the mother and the other parent is excluded. I think we need to include in there the language related to the alternating weekends or alternating events of the children, and include the language that we used previously in paragraph 8, which was the phase 5 language, and maybe making reference to it, or maybe just removing that language under H and including the phase 5 language related to alternating events of the children. Your analysis is fine. So I think those address the issues that I had on the parenting plan. So if I need something else to address, please let me know.
I think those are all the issues.
Okay. All right, then let's go then to let's just jump over to the attorney fees. The attorney fees, I see, Ms. Schoenborn, I think given the circumstances, there was absolutely no way she was going to be unrepresented in this. She needed an advocate, she needed distance, she needed a clear buffer to represent her. So having an attorney was, I think, absolutely crucial for Mr. Schoenborn. It sounds like in his view, he definitely got burned by not having an attorney, and he was unemployed and not having money or not wanting to spend money, or maybe pull it from the 401k to spend for an attorney. He at least he feels that he got burned on that 15-year no contact order. That's his impression. And there were a number of issues related to child support, contempts and the like. It wasn't all one-sided. Ms. Schoenborn was pulled in for a contempt, but a variety of contempt issues were brought because of Mr. Schoenborn. There is a disparity of income earning power, close to double, if not double. So I'm going to award $17,000 be paid from Mr. Schoenborn's West Rock retirement account to Ms. Schoenborn. Then let me just see. As far as the personal property, what I know is that there are some tools, the Milwaukee brand tools, the me just pull this up here. And then some husky tools and the like. And apparently some of those tools were the tools of Mr. Schoenborn's father. There's some electrical equipment, golf clubs, paintball, gun in the attic. So there's some rationale, I think, from all parties, probably just let's hold off. Let's keep things just kind of chill on that. Let's let the dust settle a bit and let's kind of hold off on the transfer. So we've been holding off on that for a while. Sounds like this, all the property was either gained during the marriage or was on loan from another third party. So I think that I don't have a lot of specificity of what those tools are. It sounds like there is a specific list that's been kept by Mr. Schoenborn. So I think any Milwaukee tools and Husky tools that were acquired or loaned to the family during the marriage need to be returned to the father, along with any electrical tools or just leave it tools, and then any golf clubs and the paint gun. I think those paintball gun need to be returned.
Okay.
Then, as far as the firearms, I think that the parenting plan addressed the firearms, that Mr. Schoenborn is not to have possession of those during any period of visitation. Was there a further request related to the firearms? I think Ms. Baldwin, you said something about Ms. Schoenborn retaining possession of those.
There is a handful of firearms. They didn't really raise it in their arguments, and so they just remain where they are, and that'll be fine.
Ms. Holder?
My understanding is that a lot of the many of those firearms, if not most, belong to Mr. Schoenborn's father, and the parties had been holding off on what to do about those until a trial. And since now we've been heard on the issue, and we didn't really raise it here, we would just ask that Ms. Schoenborn be restrained from keeping them and getting rid of them until Mr. Schoenborn's father is able to bring an action to recover those, however long that takes.
And again, they didn't provide any testimony about the firearms at all. Respectfully, the court can't limit my client because a third party might file something in the future. So I think that that's just one that the court leaves them where they are, and they'll be dealt with eventually.
Okay, so I think here that I will just include that restraint upon Ms. Schoenborn not to sell or dispose or exchange those firearms for a period of 24 months. So that puts, at least there's an end date to it. So if the father of Mr. Schoenborn wants to bring an action to recover those, then he would have that time frame to at least initiate an action and provide proof that they're his and the like.
I think those are all the issues, Your Honor.
Thank you. Ms. Holder, any items that you feel have been overlooked or need to be clarified?
One thing that I would like some clarification on when it comes to Mr. Schoenborn's UAs and the hair follicle testing, we would like the court to clarify on Suboxone and methadone, as that is a part of treatment. And so if he does test positive for those things as a course of treatment, that would not be held against him.
Ms. Baldwin?
So that wasn't one of the issues that they raised. As far as this was an agreed parenting plan, except for certain provisions, that was not a provision that was contested whatsoever, or referenced whatsoever in sort of the exclusions. They had agreed to that section. So I would disagree that it should be added now and that they can argue for its addition now. If and when he's tested, and if he tests positive, he's going to need to provide appropriate documentation, and then we'll see where we go from there. But my client wants him to get treatment, but at the same time, we have a long history of also abusing those substances. And so that is a significant concern.
And may I address that, Your Honor?
Yeah, please.
Mr. Schoenborn would be more than willing to provide evidentiary support and documentation that he is using those as a part of his treatment. And the issue was raised during Miss Baldwin's closing, where she said, you know, he uses Suboxone or he uses methadone as a replacement for the other drugs that he was using. And it is true that he has, you know, obtained it illegally, but we are asking that if he has it legally as a form of treatment, and we would provide documentation that it not be held against him for treatment purposes.
And again, parties should be held to the agreement that they reached.
So there was testimony related to medically assisted treatment, that he's under methadone. He's at the Kelso Clinic, I understand. So he's required to provide some hair follicle testing under phase 2, and as part of his SUD treatment. And the thing with those, at least with UAs, they can quantify those levels, you know, and you could see those levels, if they're excessive, if they're beyond maybe kind of the therapeutic levels, that would show up at least there. As far as the hair follicle test, yeah, it's going to go back 3 months, and it's going to show if he's taking methadone during that period of time or not. The fact is, it's going to show up. I'm assuming it's going to show up one way or the other, whether it's a UA or within the hair follicle test, and that would be manifested. And then if in response he has, you know, a prescription, or the SUD folks say, yeah, this is what we're working with, and that's a showing, that shouldn't necessarily be held against him. Obviously, if there's extenuating circumstances with maybe a UA that has exceptionally high levels of methadone or some other prescription, that would be cause for concern, obviously, and could be subject to any type of motion. But regular therapeutic manifestations of medically assisted treatment, upon proof that he is in treatment and he is receiving that prescription, should not necessarily be held against Mr. Schoenborn, because he's compliant with that prescription and medical advice. So I don't know if that directly addresses it, but that's at least my thoughts on it. And I'm open to any suggestions or criticisms. Okay. Any other items, Ms. Holder?
No, Your Honor.
Okay. So we have the parenting plan, which has been doctored up a little bit, but it sounds like it needs a little more attention, with at least one paragraph near the end. And I'm just curious if the parties would prefer to.
Here's my preference.
Yeah,
I'll just be plain. My preference is that you enter everything but the parenting plan. I'm fine that you just, if you want to just add to the bottom of A and B, 4 times. There's 2 on the findings, 2 on the decree. Milwaukee and Husky tools to be delivered to Mr. That's fine. The parenting plan, I can make those changes. I'll try to get them to opposing counsel by tomorrow. But that way we'll have a clean copy. There's enough kind of, because you wanted to add that language, and I think it's chunky enough that I'd rather make modifications in-house.
Okay, so your suggestion was, as far as the personal property, just pencil that in, pen it in, if you will.
Yes.
I can do that.
And that would go just to the bottom of Exhibit A and Exhibit B on the last 2 pages of the findings and the last 2 pages of the decree.
I'm looking at findings, and I can just put that under 21 and a half.
Oh, if you just turn to the exhibit, though, to the next page.
Oh, okay.
So you should write in, if you turn to the next page, there's a blank at the very bottom for attorney fees. And so you can just write in the 17,000, and then immediately under that, Husky and Milwaukee tools to Mr.
Okay, so I'll put the tools and the golf and paintball and the electrical stuff. I'll put that there. I've returned to respondent. Okay, so I'll do that.
Okay, and then you just repeat that 4 times. So A, and then the very next page, B. My A and B's have the same language at the bottom for both parties on kind of some of the stuff that's visible. So you would just put in the 17,000 on the blank line, and then the same language behind the final divorce order. The last 2 pages are A and B again. They're the exact same exact same. They just, you would just
Oh,
add them.
okay, I see where you're coming from. Okay, I caught up now. Let me just, I'm gonna put a couple sticky notes there so I get it. Okay, I've got that. I'll do that.
Very
so
good.
I'll-
And
I'll
so
s-
with,
Yeah,
go ahead. With that, you can enter, once you're ready, you can enter those 2 orders along with the order of child support and the child support worksheets. Those can all be entered today. And then we'll just circulate the parenting plan. I'm not anticipating needing a presentation for that. I'm hoping to get that to opposing counsel by tomorrow morning.
Okay, that sounds great. All right, thank you, Ms. Bolden. Ms. Holder, any additional items on your end?
I do not have any, Your Honor.
Okay, all right. I really appreciate the parties' hard work in coming to an agreement on so many different issues. I mean, I think that bodes well for the future for the children, that the parents are able to at least work together through their attorneys to get stuff figured out. And just I wish everybody a happy and good life. Thanks, everybody.